I hope everything is going fine. Today we are covering Doctrine of Ultra Vires. This topic specifically is really important for company law. It relates to Memorandum of Agreement of a company, which is the basic constitution for a company. If you do not know anything about MOA, I would suggest you go back and study MOA first and then come back and see what's going on in this video. Now, let's talk about Doctrine of Ultra Vires and break it down. What does Ultra Vires mean? On your screen, you can see it basically means acting or done beyond one's legal power or authority. We see that in an MOA, it tells you that company has been constituted to do certain things and it should abide by that. So what we are saying in essence is that when a company is acting beyond the scope of its memorandum, its actions are ultra vires. And that's Doctrine of Ultra Vires. What would be the result of such actions, you would ask? It would mean that all these actions that are taken beyond the memorandum are void. And I would love to explain it to you through this case law, Ashbury Railway Carriage Company versus Riche.
You will see that Ashbury Railway Carriage Company was incorporated to make and sell railway carriages. It can act as mechanical engineer and can work as general contractors. And this understanding would be extremely crucial for us to decide this case.
Now, the company's director, the Ashbury Railway Carriage Company's directors, entered into a contract with the defendant to finance the construction of a railway line in Belgium. The company later realized that this agreement is invalid because it's entirely outside the scope of the work that is designated in the Memorandum of Association, which to the defendant felt like betrayal. So he sued the company and we landed up after appeals to this particular case. So the legal question is, did the company have the legal capacity to enter into a contract like building a railway line in Belgium? The ruling said that a company's powers are strictly confined to the activities that are defined in Memorandum of Association, and any contract which is made and falls outside the company's stated objectives, it is legally void ab initio. That means it's invalid from the very beginning and cannot be enforced. One interesting thing that the court went on to say here is that because it's an ultra vires act and it lacks legal authority, it cannot be even validated or ratified by the shareholders afterwards. So that means you cannot sign a contract today which is ultra vires and then at a later point ratify it by voting on it and saying that, hey, all of the shareholders now agree that the stated objective of the company is expanded to mean a construction in Belgium as well. That wouldn't be allowed. This contract is void ab initio and there lies no legal remedy for Riche.